Yes, Mr. Caldecott, we've received an application from the Times newspaper for some more materials. We're inclined to deal with that at the end of the hearing rather than interrupting the hearing now.
Well, thank you.
Can you remind me if
I will, Lord, yes. Whatever phrase one uses, cut to the chase or elephant in the room, has plainly a pivotal submission which is interesting the court. And that submission, as I apprehend it, is this. The notion that republishing the accusations in the letter doesn't rebut anything save for the olive branch which the judge accepted. Because it's plainly a matter of interest to the court, I propose to take that first. But before I do so, can I just do a little scene setting, just reminding the court about the three public interests engaged. The first is the corrective public interest. Reasons I come to will say this case goes well beyond that, but there is plainly a corrective public interest. Now, for those purposes, it's important just to quickly look at the code, if we could, not least because the court is obliged to have regard to the code on these issues. What is Bundle 2, Authorities Bundle 2, at tab 40. The learned friend took you briefly to it, but it actually pays slightly closer scrutiny. As the court will be aware, some of these headings have asterisks, and those are the asterisk ones are the ones which engage the public interest box at the bottom right-hand corner. And unsurprisingly, privacy is one of them. Privacy is point number 2, coming straight after accuracy, perhaps reflecting it's a very common problem which the media have to confront. The wording of 2.1 broadly echoes the terms of Article 8. Roman 2, editors will be expected to justify intrusions into any individual's private life without consent. Then this sentence, which needs to be looked at carefully, in considering an individual's reasonable expectation of privacy, account will be taken of the complainant's own public disclosures of information, and then a quite distinct subparagraph about the material complained of, and the extent to which the material complained about is already in the public domain or will become so. Now, we submit that the phrase public disclosures of information is plainly dealing with something wider than the mere material complained of, were it otherwise the same wording would be used throughout. Now, the public interest exception appears in the bottom right-hand corner. There may be exceptions to the clauses marked asterisk where they can be demonstrated to be in the public interest. The public interest includes, but is not confined to, indeed there are public interest issues here which don't easily fit within this list, but a very important one, and it's common ground I think between the parties, is that Roman 3, protecting the public from being misled by an action or statement of an individual or organisation. Can I just remind the court of 2, there is a public interest in freedom of expression itself. And as the court will know, Article 10 is always engaged. Article 8 is not, but Article 10 is always engaged. And then at 4, editors invoking the public interest will need to demonstrate that they reasonably believed publication or journalistic activity taken with a view to publication would both serve and be proportionate to the public interest and explain how they reached that decision at the time, which of course is what Mr. Verity sought to do in his witness statement. Can I just for a purely historical observation, and we needn't go to it, the code as it was before Lady Hale in Campbell had no reference at all to having regard to public disclosures of information by the complainant. I'll just give the court, if I may, the reference where you'll see that. It's Authorities Bundle 1, tab 18, at page 393. So that's the first corrective public interest, and it's plainly one which is interesting the court, and I'll have to come back to it.
Could you remind me, Mr. Caldecott, where the reference is to the code in the judgment? Which paragraph it is?
Well, that's one of my 159. Helpfully.
Well, and 32.
And 32, yes, I remember it's in 32 very early on, straight after 31, which is the one. 32.
Did you say the code in Campbell had no reference to the material complained about?
No. Had no reference to material disclosures of information by the complainant. That wider passage doesn't appear. I'm happy to show it to your lordship.
No, that's all right. That's all I need. Thank you.
Now, the second, quite different public interest, because it's, in a sense, a public interest exercised by an individual citizen who is under attack. And if he's been publicly attacked, his only recourse is to find a media entity to carry his reply. It's a completely different public interest, but a very important one. Now there I am prepared to accept for present purposes the learned friend's catch-all of fairly relevant. But if I just may remind my Lord the Master of the Rolls, who said that our only complaint about the law was really the necessary burden point, we do take issue quite importantly with the way the judge characterises this legal duty at points 6 and 7 of our note.
Sorry, this legal duty?
No, it's not. It's not a legal duty. It's an interest. The public have an interest once the attack is made in hearing the victim's reply.
Yes.
And the test for the reply is whether it's fairly relevant. I'm using my learned friend's phrase so we can try to reduce the amount in dispute.
Well, I mean, you say in 6 and 7, the judge was wrong to hold that a person is not entitled to reply to an attack if he or she merely believes his portrayal is untrue. But that doesn't perhaps address the point that is made against you. And then you say the parameters of Mr. Markle's entitlement to make a reply to the attack are much too narrowly stated by the judge.
Yes.
So what should the judge have said at 114 to 120? You know, we need to know what you say was wrong. And I have no note of your having referred to 114 and 115 in your opening submission.
Well, can I come back to this when I explain how we say this works on the facts? Because...
Well, I do. I mean, you can.
Yes.
Of course you can, Mr. Caldecott.
Well,
I'm struggling with your appeal because it's You know, even the 12 paragraphs of this note, which I can tell you I have studied and re-studied, seem to me, if I may be bold, rather diffuse. If you're saying that there was a triable issue, I need to have it shortly stated. What was it?
Yes.
That there should have been, judge should have sent for trial before he was justified in deciding the case. If you're saying the judge made an error of law, it's no good, if I may respectfully say so, saying it was too narrowly stated. I need to know what the error was.
Yes. Okay. I did, defending myself, it doesn't matter, but I did go to Lord Atkinson and did say what our position was, and Lord, it is in tab 43 of Authorities Bundle 2, and I specifically stated that this was the correct proposition.
Sorry, Lord Atkinson at page 1.
In Adam and Ward at 1725, page 10. I'm sorry.
But Adam and Ward is not a case that applies to. It's a defamation case, isn't it? You say it's directly. The judge ought to have found this defamation case directly reading across to privacy.
Yes. Lord, I'll come to why I say that. In this particular context, he might have honestly and on reasonable grounds believed that what he wrote or said was true and necessary for the purpose of his vindication, though in fact it was not so. Now, this is, I quite accept, this is only looking on the Article 10 side, and I've accepted that in a privacy case, one has to look at the privacy side as well. But if Mr. Markle honestly and reasonably believed that what he wrote was true and necessary for the purposes of his vindication, that is highly material, we say, to the weight of the Article 10 right.
Well, what if it objectively is not?
Oh, well, that's the elephant in the room, which I have to come to on the facts. Well, absolutely. Now, I totally accept that's an issue because the court says, well, at least my friend says, that the letter doesn't rebut anything and I need to deal with that. Of course.
As you pointed out right at the beginning, is the key point in the case.
Yes, well, absolutely. That's why I'm coming to it.
I mean, the fact that he honestly and reasonably, I mean, to be honest, what Mr. Markle honestly and reasonably believed is slightly overshadowed when you read this document by what your clients were writing. I mean, your clients used the letter as a vehicle for Mr. Markle's responses. One can imagine how it happened. They said, we got the letter now, she said this, what do you say? And then they wrote it down and reported it. Now, that is not really the stuff of a response to the People article.
Well, that's the critical issue. We say it is, and I'll explain why in a minute. But, Lord, can I just... I always knew this opening setting the scene might irritate the court, but it is...
You never get irritated,
no,
Mr. Court.
But, Lord, it is important to appreciate these three different public interests because they are different. And I'm just setting the scene. It really is important because they have different consequences.
So the first public interest
is the corrective public interest, which reflects the code protecting the public from being misled.
Yes.
The second public interest, and I entirely accept that if Mr. Markle was wrong in his reasonable belief, then he obviously fails.
The second public interest
is the right of reply, Mr. Markle's right of reply.
Mr. Markle's right of reply, yes.
And the third and much wider public interest is in the continuing debate prompted by the People article. And the judge rightly acknowledges that in the paragraph we don't object to, at paragraph 31 of his judgment. Now, I'm just taking this in stages, if I may, because it's important. Fundamental to all three of these public interests is firstly identifying the charges made or arguably made by the People article, both individually and in terms of their cumulative impact. Having identified the charges, both individually and cumulatively, you cannot assess or balance the competing Article 8(10) rights, bearing in mind Mr. Markle's Article 8 right is also engaged, without considering two critical factors. One, to what extent the charges can be shown to be false or misleading. And secondly, what, and I put in brackets, if anything, because my friend says nothing, what, if anything, the text and tone of the letter contribute either to the wide public debate or are germane to the right of reply or contribute to a correction, shorthand for protecting the public from being misled. Now, I have obviously been through the People article in some detail already. Can I just, because my learned friend quite frequently used the term passing reference and matters of that sort, but just have a look, just for completion on this, at Full Bundle 2, tab 21, page 403 to 4, this is a follow-up article online in People magazine, almost entirely focused on Mr. Markle. Now, can I formulate, if I may, what we say is, or arguably is, the sting of the People article, the charge that we are concerned with? And this is fundamental to why we say...
Well, we won't get the sting of the People article by looking at the follow-up, will we?
Well, you have to look at both. You're quite right. You get this. This is very similar, but it doesn't include the lying. What? It's part of apparently it's part of the same thing, I'm told.
Well, it's on the same date. It's dated the 6th
Yes,
of February.
I think it actually is actually part of the same. Yeah. Now, my Lord, can I just formulate, because this is absolutely central.
Yes, please.
What the sting is of the People article overall. In the teeth of his daughter being always dutiful and supporting him throughout with incredible generosity, first he cold-shouldered her at the wedding at the most important point, or one of the most important points of her life. Secondly, he's lied about saying she'd shut him out. And thirdly, he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Sorry, just say that last one again.
Sorry, my Lord. Her pleas for reconciliation in a loving letter.
And third, he ignored her pleas.
Yes. No, sorry, my Lord. Yes, he gave a cynical and selfish response, ignoring her pleas for reconciliation in a loving letter.
Just say the whole thing again. He did what?
The third is he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Okay, That's rather more complex than you put it before, right?
Well, I made the submission before.
You made the submission in more general
terms, but it always struck me that it might be helpful to formulate a sting so the court.
Right. I want to read it out back to you, I'm afraid. In the teeth of his daughter being always dutiful and supporting him with incredible generosity, he cold-shouldered her at the wedding, the most important moment or point of her life. He's lied about her shutting him out. And third, he gave a cynical and self-interested response, ignoring her pleas for reconciliation in a loving letter.
Yes.
Right.
Now,
thank you.
Sorry, my Lord. Can I just explain? Now, this is a submission I made when I opened the appeal. There's, and I think my Lord Master Rose also mentioned this, there's a synergy between what is said about her and what is said against him.
Yes.
It's the more appalling, his behaviour, because of the exceptionally loyal and dutiful way that she has behaved to him. It's all of a piece, and what is said about her and what is said against him are an integral part of the attack. Now, what my learned friend seeks to do is to pick out the individual allegations, but to crucially exclude from them what is said about the claimant. Because the problem he has is this. The letter, the text of the letter and the tone of the letter show that it's not a loving letter, is not a generous letter, and when we come to the very first allegation about cold shouldering at the wedding, crucially, this allegation is demonstrably false. We say, and on any view we have an arguable case that it's false, that he cold-shouldered her in the run-up to the wedding. But the point is this: if her letter to him includes a thoroughly nasty and untrue allegation, which we say this is, the very fact that she makes that false allegation in the letter runs contrary to the whole way she is portrayed in the People article, which aggravates the allegations against him very considerably, we say. Now, the court has my submissions that the judge doesn't grapple with the falsity of the pre-wedding charge at all, and that his selection of texts excludes the crucial ones that give the lie to it. Now, my learned friend, and I listened very carefully to his submissions, did not advance any argument, really, that with the exception of the paparazzi photographs, there was any truth in the pre-wedding charge of cold shouldering. The paparazzi is a complete diversion, and the court should ignore it. Mr. Markle apologised for it, and his apology was accepted. Now, what about the suggestion that he'd lied. And this is a serious charge. He'd lied in saying she'd shut him out. Now, that is something that the public are being told. To a degree, the truth of that is a triable issue, but she accepts herself that there was no contact between her and him at the wedding. And if we go to the letter, we can see that this allegation is noted. I've already taken the court to where the letter makes the wedding allegation. It does so in a number of places.
Sorry, can we look at it? Which page?
Well, it's convenient. Paragraph 45 of the judgment is probably the easiest place to look at the letter, because it has a helpful number of paragraphs.
Yes.
On the wedding allegation, I mentioned these before and went through the small words. It's the bit at the end of 1, 2, 4, 7. And on the cutting off allegation, 14 is material. You haven't reached out to me since the week of our wedding. And while you claim no way of contacting me, my number has remained the same. Now, Mr. Markle, we know, says that too is untrue. I've sent numerous texts and I get no response. It's in the Mail article. This is, again, an issue which can't be tried now. So again, it's relevant to look at the letter to see really whether the daughter is treating her father dutifully, generously, or fairly. And lastly, and not insignificantly, the letter is presented in the People article as a loving letter. What is the best evidence to refute that but the tone and text of the letter? We pleaded that it was necessary, not because that is a legal test, but because it was necessary to put the public right about these matters. This is all at the moment. I'm looking purely under the corrective, which is in one sense the most restricted right, but also in some senses the highest right, because it really is important. It's expressly mentioned in the code about protecting the public from being misled. And now we get to the second public interest, which is his right of reply, which is triggered by the attack. Lord, I'm not going to go over old ground. I've made extensive submissions about right of reply. Can I just emphasize this point about autonomy? If you attack someone or cause somebody else to attack someone, and the attack refers to an ostensibly private document of yours, which certainly contains material relevant to the kind I've indicated, you're plainly loosening your autonomy. One can have a fascinating philosophical debate about whether allegations against Mr. Markle in the letter, are they shared information, are they her information, what exactly are they? But whatever they are, if the law acknowledges the importance of a right of reply if you're publicly attacked, you must be loosening your autonomy in the information. Assuming for the sake of argument I'm right about the letter having some, or more than some, having real relevance to rebutting the attack, you're necessarily loosening your autonomy.
Well, are you criticising the judge really for not looking to see what the attack on Mr. Markle was, but only looking to see if there was anything in the People article that was inaccurate?
Yes. Yes, well, we are, because we're saying the attack on Mr. Markle is wider, and part of the problem is that to take what in some ways might be thought to be the most hurtful thing about the pre-wedding conduct, he doesn't really go there at all.
But you're also, the problem that is your elephant in the room is that the letter is not automatically to be taken, as you assume, as a further example of bad conduct by the Duchess. The letter, the Duchess would say, I'm sure, was an attempt to put him right, absolutely, about the press, but was not unloving, not unkind, just justified. So your assumption is that this letter, which is, in her eyes, loving and fair, putting him right, in your eyes, unfair, says bad things, says wrong things about various tribal issues about the wedding, is a sensible or reasonable rebuttal of those points, when really it's just more of the same of the people, isn't it?
Well, look, with respect, we simply don't agree. I mean, there's another facet to this, of course, which is the fact that the letter was given to the people and the judge accepted. We had a triable case.
No, what? No.
Sorry, not the letter, I beg your pardon. That friend A spoke to the people to whom she had spoken, and that we had an arguable case that she was responsible for the People article.
Yeah.
Now, it is a very curious position that merely because you don't give the text to the people, the text doesn't appear, but you give a misleading summary of the letter, which is bigging you up and pushing him down, that the letter is somehow wholly
Why
immaterial.
wasn't it enough? I mean, why? You know, I'm as you probably worked out, Mr. Caldecott, I'm quite struck by this part of the article where there are extensive citations from the letter, followed by Mr. Markle's comments. And why wasn't it enough for Mr. Markle to make his comments by reference to saying, and she wrote to me again, or she wrote to me, telling me off, and this is what I say about it. You know.
Well, what are the readers to assume as to where the truth lies, unless you can see the letter? If I was a judge trying to investigate where the truth lay, you would want to see the letter. And the public are in no different position.
Well, except you've got a right, if she's got a right of privacy in the letter.
Well, your Lordship assumes that. We don't accept that, as your Lordship knows. We've very much been focusing on my learned friend's submissions on this started off assuming privacy, but it's a very nice question. If you start, as we plainly the judge accepted, we had an arguable case for trial, that she was in the broad sense behind the People article. The People article does two things. It firstly repeats some allegations in the letter which we say are untrue, and secondly it produces a wholly misleading gloss on the letter to her credit.
Well, doesn't it just, I mean, is that to do with the letter? Or is that just a wholly what you say to be a wholly misleading gloss on the person? I mean, is it, I mean, we need to look at this, but it doesn't seem to me that the 25 words in the People are what you're, if I may say so, saying about them. I mean, that's not the whole thrust of it. You make it sound as if the People article is just based on the letter. Whereas the People article, if we look at it, I think it's page, is it 343 or something like that?
377 is where the crucial text begins.
Right, and it's in the second column at 377. There seems to be more of it than I remember, maybe. It's the right-hand column.
Yes, it is, my lord. It's all bound up because there's the appalling treatment of him alleged in the opening section, and then in the second paragraph, immediately after all this business about him wholly ignoring her, I love you and I'm scared, it was endless. After that, after the wedding, she wrote him the letter. She's like that, I'm so heartbroken, I love you, I have one father, and so on and so forth.
But what I'm putting to you is, this is an incredibly long, somebody's going to have to tell me what is the People article, I'm afraid, because there seems to be so much of it, I hadn't realised it goes on for pages and pages. Is that all the People article?
My lord,
Yes?
as I understand it, there's a hard copy magazine version of it which runs to page 382, and then there are online articles at 8, 9 and 10 o'clock following, I think, on the same day.
Right.
And I was showing your lordship one of the.
But you see the point I'm making. If you look at, I don't want to interrupt your flow, Miss Caldecott, but it does trouble me, and your submissions would be helpful. You know, looking at the other pages which we haven't trawled through, it's all about what a wonderful friend and person the Duchess is, right? It's nothing to do with the letter at all. She's funny. She's makes the room laugh. She's selfless. She's very kind to people, and so on and so on. Pages and pages and pages.
Yes.
And so why would you, in rebutting the suggestion that even about Mr. Markle, you know, it's super painful because she's so dutiful, she's devastated. The rebuttal, why does it have to involve the letter, really? What's that got to do with it?
I mean, it seems to me that...
I mean, why can't he write it? He can ask the People to publish, or the Daily Mail, or anybody he likes, to publish a rebuttal saying, I'm a very dutiful father, and she wasn't what she said she was.
Yes.
Or am I missing something?
Well, I think with respect, one is.
Okay.
Because it is just worth looking at how the Mail article opens, what it says, leaving aside the...
So are we in the Mail or the People?
In the Mail, just for the moment, because this is, as it were, the reply.
Mm-hmm.
And you'll get the first three. Mr. Markle says the letter, paragraph 4, today, far from conciliation, has left him feeling devastated. The bombshell 5-page letter lays bare the true depths of the father's estrangement. She accuses him of breaking her heart into a million pieces. And then there's a bit about his talking to the press. And the article is fair. It acknowledges, it does mention material in the claimant's favour.
But the problem with the article is that what the article is about is a big splash. It says in the first paragraph, the full content of a sensational letter written by the Duchess of Sussex to her estranged father shortly after her wedding can be revealed for the first time today. It does not say this is the response of Thomas Markle to vile allegations made against him in the People magazine, which is not what it's about. It's about splashing the letter. and they say, well, you know, you knew it was her letter, you knew there was a right of privacy, you're journalists, you had a responsibility to ask her if she minded her letter being splashed all over the tabloid newspapers, and all you did was make it into a big article.
Well, I'll come back to the notice point, which, as we'll see, has no merit at all.
Well, it's not that it has no merit, it's a fact, isn't it? There was no notice.
Well, anyway, I'll come back to that later, to what my friend said about it. Can I just, the big column just under the photograph how Meghan's media fight back led her dad to reveal the letter he wanted to keep secret.
Mm-hmm.
Remember, he'd honoured the privacy in this letter until the People article appeared. The Duchess's father told no one about her letter and planned to keep it totally private out of respect for her until her friends launched their attack on him last week. The article painted Meghan in a glowing light while insisting the negative stories about her were lies. But Miss Markle says the decision to reveal the letter left him with no choice but to go public. The letter was presented in a way that vilified me and wasn't true, he said last night. It was presented as her reaching out and writing a loving letter in the hope of healing the rift, but the letter isn't like that at all. Either we believe in freedom of expression or we don't. But Mr. Markle has been royally attacked in the People magazine in precisely the way he there describes. And this is his reply. And one goes through the early columns, it goes through various allegations.
Yes.
And his, as your Lordship rightly said, and gives his reply. Now that, it brings me again, in a sense, to the wider public interest in this case. If you read the People article, you don't know for certain to what extent the allegations were authorised by the claimant or not. It says friends very close to her. Now, there's particular significance of the pre-wedding allegation, which is false, is that it can only be known about, essentially, by the three people who were party to the essential communications, which is the claimant, Prince Harry, and Mr. Markle. So it's perfectly reasonable for Mr. Markle to assume that the claimant was responsible. And also, one would have thought quite reasonable for him to assume that the five friends did have her approval to state these private things on her behalf as the truth.
And the judge assumed that.
Yes, yes he did, but it's all part of the fabric of enabling him to deploy the letter. And there is this core difference between this case and the Prince of Wales case. In the Prince of Wales case, documents marked strictly private and confidential were taken to the mail by a servant who was under a contractual duty of confidence. And the court took the view that it was essentially the prince's private thoughts or private reflections on his travels. And although there might be some public interest, it couldn't outweigh, and therefore they gave summary judgment. But this letter comes to the newspaper in very different circumstances. It comes from someone who on the face of it has got a right to reply, and what they are doing, and effectively the Mail, we say, is giving him an opportunity to do so.
Well, I mean, that's fine, but it's what tools you use to reply, isn't it? That's the key issue here.
It is the key issue here, but
perfectly entitled
yes,
to reply.
but this is a very important case about the ability to deploy private text which is relevant. Can't be said. How could the letter possibly be said to be wholly irrelevant to the issues which are being raised by the People magazine?
Who says that? Who says wholly irrelevant?
Well, Lord, it's an important question. My learned friend says it's wholly irrelevant because it doesn't show anything by way of rebuttal.
Not sure he says wholly irrelevant. It does show some things by way of rebuttal. As we know, it shows, it rebuts the allegation that it was an olive branch.
Yes, I'm obviously I've conceded the olive branch is, that's something the judge, he let in one paragraph of the letter, I think it's 15, on the olive branch basis. But
yes.
We say that's far too narrow. I mean, this has really quite important consequences for investigative journalism if it's to be said it's unarguable that you can deploy the text of a material document which is ostensibly private in circumstances such as this.
To what extent does it matter that in your paragraph 15.6 of your re-amended defence, you refer to the fact that the matters you set out were relevant, you say, to Mr. Markle believes and has informed the defendant that this was wholly false. In other words, that you didn't say it yourself, because that's dealt with by the judge. One looks at this part of the judgment.
Yes.
And dealing with paragraph 111 and 112, and what he's looking at when he deals with your case on this is what you pleaded, what your case is on the pleadings. The starting point is it's assumed that the claimant has some responsibility for the references to the letter in the People article. That's assumed in your favour. But, and then he then goes on to say in 111 and 112, it's hopeless. And he says if a published article gives a one-sided account of a relationship and that account is false or misleading and damaging to a person, that might prove some justification. But there's no authority to support the view that mere fact that the person believes.
Lady, this is unfortunately, there is some, can I accept, there is some merit in the judge's view, and I'll come to it if I can just find the page of my earlier submissions. I didn't go into all of this because, of course, I'm slightly running out of time. But there's a whole raft of pleadings about this, and it's fair enough, I think, for the judge to say that at times there's some slippage between objective falsity and a subjective reasonable belief in the falsity. But there is also a fair amount of objective falsity. There are a whole lot of references to the pleading which deal with this. Yes, I know, I just had to find them because I've got a list of them. Yes, my lady, could I just answer your question? It's a perfectly fair question. If one goes to the defence at CB1, CB2, I'm sorry, tab 21. Page 329, I think is the best place to start. And a whole host of paragraphs which need to be looked at. Can I just say this before going to them? All the relevant texts are set out in the defence. 13.8.6, the plain meaning and effect of the hard copy article of the 10 a.m. People article was to suggest that Mr. Markle has made false claims about his dealings with his daughter and that he was entirely at fault in not attending the royal wedding and of the estrangement between himself and the claimant. 13.8.11 is a point about not complaining, not seeking to put it right in People magazine. And then 13.8.11a, on the day the People articles were published, Mr. Scobie appeared and said no true friend of Meghan's would speak out publicly without her very subtle blessing. Mr. Scobie said that while the purpose of Miss Meghan's letter was very much to repair the relationship with her father, she knew in her heart of hearts this was going to be released to the papers, so many of these things in the letter were written with the public in mind. And then in 15.4, and we could forget all these long particulars, if we go to 15.4, this is an important paragraph. The People interview depicted Mr. Markle as having acted unreasonably and unlovingly, having cold-shouldered his daughter, and being solely to blame for the estrangement between father and daughter. This was a one-sided and or misleading and false narrative.
I follow that. So then, if one goes on to 15.9,
yes,
if this is where we deal with the, or you deal with the, it might be called a contrast between what's in the letter
yes.
and in the People article. Is there anywhere else that we need to look at for this purpose, where you deal with this in your pleadings? That is a contrast between what you're saying positively as opposed to through the mouth of Mr. Markle.
There's another one, 15.8. Look, People also stated that Mr. Markle refused to get into the car, suggesting he refused to attend his own daughter's wedding. This was also false. 15.9, so we can repair origin. This is more on the olive branch, I accept. This information was false, as is now admitted. Also 15.9,
And then we've got
about the loving letter. This was false. It wasn't a loving letter. The ladies, I think the judge was critical because there are occasions, and 15.7 is an example, where it says, never called and never texted, that he falsely complained that he couldn't reach his daughter was, according to the claimant's father, untrue. But there's an air of unreality about this, because after this original defence was served, all the texts came in attached to the re-amended reply, and they, we say, plainly demonstrate, or arguably demonstrate, that this allegation was plainly false, that he never texted, and it really would be completely unreal to approach that issue on any other basis. And then just to give, I think they should have asked any other.
photo op in 1510.
17.8.2, the words in Article 2 that the claimant had blasted her father for not telling her that he would not walk her down the aisle would be clearly understood to be an interpretation of the words of the letter quoted immediately after. It was true that the claimant had accused her father in the letter of not calling to tell her he would not come to the letter, as is apparent from these words.
What I'm really looking for is the parts of your case which say this is what the letter said, and this is the fact.
Could you find the word echoing references to the letter? Yeah. Well, I think 15.9 is perhaps the most important.
Yeah, thank you.
You've been using the phrase a loving letter. Is that your summary of the gist of the italicised words at 15.9.234? Dad, I'm so heartbroken, I love you.
Yes.
I'm father.
Yes. Now, there is interesting point here on the Article 8.10 balance. The learned friend did not challenge, I'll be corrected if I'm wrong, our criticism of the judge for saying that the effect on Mr. Markle was modest. Did you?
Yes.
Well, we submit, and I said it in opening, there was all sorts of reasons for assuming that it is at least arguable that when he said he was shocked, and you can read his witness statement about it, no reason whatever to doubt that he was telling the truth. And the ladyship quite rightly pointed out that Article 8's core value actually is about the ability to interact with our fellow human beings, and the loss of dignity and so on and loss of autonomy can affect that. But if one is actually looking here, balancing on the one hand the real weight of the loss of privacy in the letter, if there were any, against the effect on Mr. Markle's Article 8 rights, both his family life and his reputation and his ability to interact with people, we would say the balance on any humane view comes down firmly on his side. And that is a real problem with the judge simply saying the effect on him was modest. There was no evidence on which he could properly base that, we say, having regard to the seriousness of what had been said against him. Now, can I just say this while I'm on it about the wider public interest? In fairness to the Mail's article, it does give points from the letter which are in the claimant's favour. It does explain that she was right to criticise him about the paparazzi photographs, and it also refers to the later interviews he gave as damaging. It does not give a wholly one-sided view of the debate. I mean, it's often said against newspapers that they simply just give one side, but they do give that side of it. This raises another issue about the letter. Anyone reading the People article would be interested to know whether or not the claimant was a co-accuser. Was she in any way herself making these allegations? That is a genuine matter of public interest. And she was indeed the source of the allegations about the pre-wedding period. And in view of her position, it's a perfectly proper public interest to show that she was, and that requires deploying the text of the letter to make that wider public interest point. I may add that her deployment of the letter, as to which we have an arguable case, I mean deploying it in the broad sense with the People, is plainly a relevant factor at the first stage under Murray and under the Code. It's a material disclosure of information to this particular debate. And it's clear that the editor, he's told by Mr. Markle that he believes his daughter behind it, but you've only got to look at the allegation, particularly about the pre-wedding behaviour, to see it would be very surprising if she had nothing to do with it. Now, either freedom of expression is now so downgraded that you apply a pretty granular analysis, you ignore parts of the sting to which the letter is plainly material as a rebuttal. And if that is so, we respectfully say that is a material change in the proper approach to the balancing exercise. Which brings me to a point on Campbell. What lost the defendants that case was the fact that publishing the photographs interfered with Miss Campbell's medical treatment, because she would not go back to her Narcotics Anonymous place she'd been visiting for fear that there would be long-lens photographers waiting for her. That case was decided very firmly on that serious interference with her treatment, and the majority judgments are all about the intrusive effect on her treatment. That was the decisive factor. Where is the equivalent factor in this case? There is nothing even approaching that kind of seriousness. Now, my Lord, I hope that's really my submissions on the main question. Except I should just deal with one further point about why this is quite important. The learned friend said that the book account of the letter was simply taken from the Mail on Sunday. These untruths keep appearing about Mr. Markle, and this is another reason why getting it out there is important. If you could just look, please, very quickly on this point, at Supplemental Bundle, tab 11. Bear in mind that the claimant admits that she spoke to a friend with a view to her talking to the authors about the letter. If you look at page 99, you just look at the second paragraph. This is what happens if you can't even deploy proper defensive material. Despite Meghan's barrage of voicemails and texts, Thomas had not only refused to get in the waiting car to the airport, he hadn't responded to a single message from his daughter. Now, that's not reproducing the Mail article, it's wholly ignoring it. And then there is a reference to one particular text which is on page 101. First new paragraph on page 199 of the book, 101 of the bundle. With only 4 days left to her wedding day, though Meghan received more devastating news from her father, again through a celebrity gossip website. To be fair, literally that's true. The website got there first. And then go down another paragraph to the middle of the page. Troubled, Meghan reached out to Thomas via text message. I've been reaching out to you all weekend, but you're not taking any of our calls or replying to any texts. And then 10 minutes later, she followed up with another. And then at the bottom, that evening, Thomas sent a short response saying that he appreciated the offer of security, but didn't feel in any danger. Instead, he wrote he would recover at a motel. Meghan asked for details, but he didn't reply. But he did reply. The text is at 6:43 at 4 o'clock, and he told them exactly where he was staying in the hospital. Why should the traffic on this be all one way against Mr. Markle without him showing this comes this comes from my daughter. Look what she said in her letter about this. Look at the text, which is what the Mail article sets out, the crucial 16th of May text. I did tell my daughter I couldn't come to the wedding. I was very disappointed about it and so on.
I'm so sorry to interrupt, my lord, but my learned friend may not realise that the deployment of the text messages in the book all comes from the fact that they were annexed to the reply in this action. Regrettably, they were not protected by a confidentiality schedule. We've been around the houses on this before. That's where the author's got them from. I don't know why my learned friend is making a point of that.
Well, no, I'm making a wider point than this. I'm not suggesting that the claimant caused this, but there's no plea to that effect. I'm pleading a much wider point about the public interest, about the importance of bane and antidote, and about the public having the wherewithal to make a full judgment about this. Is it just the friends who are putting it out? Is it her? Where does the truth lie? And I may add this, that the texts to which there is no objection in the article are private communications. They are part of the story. They are deployed. But there are very important and deep issues in this case about the use of ostensibly private material that has been deployed in the public domain in a misleading way, and how far the use of it can go. I'm not going to say any more about this point. Can I just move on to the precipitate point, not least because my Lord the Master of the Rolls raised it about not giving notice. The first thing to say about this is the code imposes no obligation to get consent. What it says is that you have to have a reasonable belief in the public interest and so on. If you've looked at the code, if you're going to publish private material without consent. Now, this is particularly so in the context of reply to attack. Because what happens if you go to the original attacker, the reply then gets polluted with a whole lot of secondary material from the original attacker. The purpose is to give Mr. Markle's reply. That is the purpose of it. Thirdly, the European Court has ruled on this very point in a case called Mosley. Could I just hand up 3 copies?
Can you send it electronically?
Well, certainly, of course we will, yes. It's been sent, but I hope it may have arrived.
Not yet. Oh, yes.
It's very last paragraph of, sorry, no, I beg your pardon, hasn't arrived yet. Lord, we really only need to look at 132. The court has consistently emphasised the need to look beyond the facts of the present case and to consider the broader impact of a pre-notification requirement. The limited scope under Article 10 for restrictions on freedom of the press to publish material which contributes to debate on matters of general public interest must be borne in mind. Thus, having regard to the chilling effect to which a pre-notification requirement risks giving rise to the significant doubts as to the effectiveness of any pre-notification requirement and to the wide margin of appreciation in this area, the Court is of the view that Article 8 does not require a legally binding pre-notification requirement. Accordingly, the Court concludes that there has been no violation of Article 8 of the Convention. Now, Where pre-notification does matter is in the defamation context, if, and I stress if, you wish to avail yourself of the defence under Section 4, used to be the old common law public interest defence. But if you believe that something is true or something is in the public interest, you're entitled to publish it and there's no obligation to pre-notify.
Well, the judge dealt with these sort of points, paragraph 125.
Yeah, the precipitate point.
As part of a sort of, because he says he accepts in principle it was legitimate for Mr. Markle to seek to rebut the inaccurate suggestion that the letter represented some form of olive branch, and having earlier said it would in principle have been legitimate for Mr. Markle to reply to the allegation of victimisation. The point he was making is that it wasn't necessary or proportionate, so it comes in as part of the proportionality analysis at 125.
Lord, yes. Lady, yes, sorry. And that's, there's an issue between us about that. We say that's much too narrow.
Well, what do you mean, much too narrow? I mean, he is saying it can't possibly be proportionate for these two allegations on any analysis to reveal the whole of this large tracts of the letter, because the letter is more of the same as the People article, and it's these are fairly narrow inaccuracies that he's replying to. Now, I know you say there were broader inaccuracies about the wedding and the cold shouldering and so on. But what is the legal error here? I mean, you say he's just weighed the balance wrong. You say it could be enough to allow, on a proper analysis, the whole letter in.
I say that Mr. Markle's Article 10 rights to give his version of events were strongly engaged because of the nature of the attack on him. And I say that the fairly extensive quotes from the letter, I accept, I think it's about half of the letter, are fairly relevant to getting an overall picture. And court, and I do say that it's far too narrow. One of the reasons, I mean, there are many reasons why it's too narrow, but I mean, my Lord puts to me that, oh, well, you know, he may not have spent much time on the allegation about the pre-wedding communications. The pre-wedding communications are extremely serious. We say demonstrably false. They're in parts of the letter which the judge said, for example, he was not allowed to deploy.
But I mean, the deployment of her letter to defend himself is strange when he's got a lot of text that he wrote that he could have deployed to defend himself. And what I find strange in all this is that you're not really, what you're, if I may say so very skillfully, Mr. Caldecott, as I'd expect, doing, is extending the ambit of the debate from whether Mr. Markle was entitled to defend himself vigorously against a 10-page attack in the People magazine saying he was not a good person, to make it sound as if we're opening the floodgates of destroying freedom of speech if we don't uphold your appeal, because he responded by using a letter which was of some relevance but not absolutely central to saying I'm a good person and you're wrong to say I'm a bad person. I mean, it was just one tool, and what the claimant says is it was a tool that belonged, that had a property right and also a privacy right in me. And you could have said all sorts of horrid things about me if you'd wanted to, and indeed you did. You didn't have to pin it on the letter.
The fact it may be that he didn't have to doesn't mean that he can't.
Well, of course, that's right. If you're right, you're right. I mean, I accept that. But the point is that the article, I mean, you haven't really, your answer to my question about the way that the article is pitched is to refer to a sub-headline and say this is a response to the people.
Well,
but actually, if you were reading this article, you'd read the real, you'd read the real headline and the first part, which is actually about publishing the letter and saying it's a bombshell. And nothing, you know, the people is coincidental, really.
Well, can we just look at the article, quite apart from the section which I drew attention to, just look at the opening paragraphs, the opening column of the article.
Mm-hmm. I know it gets to, well, paragraph 5, the bombshell 5-page letter. The true depths of the Duchess's estrangement. This doesn't look like a response, does it?
Well,
I agree it's pinned on the response, of course, but the point I'm making to you is that he could have responded without the letter and the world would not have ended on Friday if he'd done that.
The Lordship may, of course, be right about that, but where's the editorial latitude coming into all of this?
Right.
And, I mean, what Lord Hoffman says, I do repeat the point that if one look at the Article 8 side of it, there have been plainly, on our case, there have been material disclosure of information by her, material to this debate. And on the Article 10 side, if you look at Lord Hoffman's analysis, that you have to look at both what is not complained of in order to assess whether it's right. And also think of the reader's perspective. How are they going to believe Mr. Markle if he simply describes the letter?
Well, I mean, my point is a different one, really. What's really the letter hasn't got much to do with it. It's a long People article, which is a diatribe, and the answer to it is, you're wrong and I'm right, and all sorts of texts, and it's not true, and I did write to you, and I did phone you. It's really nothing to do with one letter. I mean, there is an allegation or two allegations about the letter, but the People article is not based on the letter.
Well, but we respect the People article, the relevant part of the People article is heavily based on the letter. Obviously not exclusively.
But you're the one who's urging us to take the thing in the round.
Yes, I am.
And if we take the thing in a round, then we don't just look at one paragraph of a letter.
No, absolutely. But
I
I was in the People article. The letter is the crucial link between bad behaviour before the wedding, and then bad behaviour after the wedding. It sits in the middle.
Yeah, and then there was a letter. But it's really about the bad behaviour.
Well, we, with respect, don't agree. He's portrayed, quite agree, he's portrayed as guilty of bad behaviour, and the Mail article points out that in some respects, that's a true bill, in some respects. That's important to the wider public interest. It is important. It's, in that sense, a balanced view, whatever one takes to view about the deployment of the letter. But the letter, for the reasons I've given, is weighty evidence that the high presentation of the claimant's conduct, which, as I keep repeating, is intimately bound up with the way his behaviour is presented, is untrue and misleading, and the letter shows that.
I suppose you say your case is summarised by Mr. Markle in the centre of the page of Caroline Graham's article under How Meghan's Media Fight Back led her dad to reveal, etc. He said the letter was presented as her reaching out and writing a loving letter in the hope of healing the rift. The letter isn't like that at all.
Yes.
She can't have it both ways. She can't use the press to get her message across, but hang me out to dry, I have the right to defend myself.
Yes.
That's putting in layman's language what you've been saying to us.
This is
whether
putting
it's
it
right
out,
or not.
yes, every bit as well as I put it actually. But the judge simply doesn't analyse this broader case at all. Nor does he engage with, as I say, some crucial issues of falsity. He lists the texts which reflect badly on Mr. Markle in terms of the paparazzi photographs. The texts which are favourable to him are nowhere. And as I repeat,
and I think in opening you were putting quite a lot of emphasis on the fact that the judge was apparently concerned with the press coverage. So was concerned with the question of the argument about whether Mr. Markle had been to the press when he shouldn't have been, and what he had done in that respect, whereas that was not the issue you were complaining about.
Yes, it's legitimate background. I don't criticise the judge for mentioning that, not least because it's in the article, and it's right to say that Mr. Markle himself does not have a fully luminous halo in this matter. But he's not so portrayed in the Mail article either.
Yeah.
And just in answer to your lordship's one other question or observation on the suggestion about notice, I hope I've answered it fairly thoroughly already. But there was here a fair amount of urgency. The People article appeared on the 6th of May. How many millions a week? 40 million readers a week is what it has. And it was immediately picked up by the world's media worldwide, leaving, one would have thought, Mr. Markle in a pretty lonely place. He's an ordinary citizen. He may have given the odd ill-advised interview, but he doesn't have the command in the media, which someone would claim he does. And we say there, in journalistic terms, was a perfectly legitimate urgency in the Reynolds sense about getting his reply out there. And what Lord Hoffman, I think it's Lord Hoffman, says, I don't say this in a defensive spirit, but newspapers do have to make, we've been discussing this now for 2 days, but the newspapers have to make a very quick decision on the material available to them. And Article 10, Moseley implies, and I think Lord Hoffman and others, I think I took your lordship to the cases, to the extracts from Campbell, have to make a decision in short order. The finding by the judge on this is really astonishingly dismissive. What was done was precipitate, largely irrelevant to any legal aim, making the fullest allowance for editorial judgment and wholly disproportionate. And we do take real issue with that. And it does bring me to the important legal point that we have on the question of burden of proof and necessary. And I made the point in opening that necessity is a very high standard in ordinary language. Now, the learned friend, could I just add to my note, well, there's one paragraph I should have put in, which in one sense is the first one, which is J35. It's in point 5 of my note. Your lordship rightly pointed out that J35 is another important, or paragraph 35 I should say, is another important paragraph in this. Now, the learned friend pointed I think two, first of all, he pointed to 104. The last sentence in particular, but that's dealing with the test for summary judgment. It's not dealing with the test under the balancing exercise. The last sentence of 104, if there's a real possibility that the publication complained of might be found justified on this basis after a trial, I ought not to strike out or grant summary judgment. And then he's referred above to preventing the public from being misled, and that's the big issue we've been debating for quite a long time. Now, 106.4, sorry, I beg your pardon, that's in this. And then it is 106.4, I'm afraid it's actually in the text. Whether the publication was necessary and proportionate in pursuit of the available justification. That is what the judge is saying he has to assess. That's not right. Now, in Campbell, when the judges are looking at the facts, bearing in mind the harm caused to Miss Campbell, it's not surprising they said it wasn't necessary to do it. But they weren't laying down the test. The problem with what the judge does is that he's using this as a basic yardstick, and it's much too strong. And then 112, we see exactly the same in the last sentence of 112. This is one of the paragraphs I take it that we discussed already about reply to attack. It's fanciful to suppose that the court would find the disclosure of the contents of the letter necessary or proportionate on the basis set out there. And then 119, this appears to be suggesting what the editorial judgment
You say that's wrong as a matter of law.
Lord, I say that that seems to be going back to the error which we identified earlier about a burden and about necessity as the standard. And again at 119, this looks as though the question that the editor should be asking himself is whether it's relevant, necessary and proportionate. Making the fullest allowance for editorial judgment, made it relevant, necessary and proportionate to make the disclosures complained of. It's the word necessary which is the particular problem. Then again, 1255, it was neither necessary nor proportionate to disclose any of the rest of the information in the letter for this purpose. It's a more generous test than necessary. And your Lordship will remember that even in the majority judgments in Campbell, they say it's not enough merely to say it would have been reasonable of the editor to have done it differently. My Lord, I appreciate.
Well, the test for correcting what's on the public record, What is that test? Which is what the paragraph was dealing in, the judge was dealing with in 125. What test should if the court
just
is,
give me a moment.
court is looking at that issue?
Yes. I just need to clear a couple of files. Sorry, I've got a lot overloaded here. Test appears to be, if one takes the code, and that's what the editor is meant. That's his guideline.
Part of.
Well, it's part of it.
It's part of the legal framework.
Yes.
It's not the only, but
No, but it's a helpful starting point because Section 12 requires us to have regard to it, and it is a code which is where they look if they have a problem. And what paragraph 4 of the code on page 1036, Authorities Bundle 2, tab 40 says, will need to demonstrate that they reasonably believed publication would both serve and be proportionate to the public interest and explain how they reached that decision at the time. Now, interestingly, and sorry, you're about. It's my fault.
I just want the answer to the question.
Well, but
it's important to know
yes,
what you say.
Yes.
You're criticising what the judge did, and I wanted to know
yes,
in a sentence what you say the test is, that it should be applied here.
Well, we say that the test of reasonable belief that it's in the public interest, it would appear to be the test one must have regard to. It's what the code requires. It's interestingly what both Section 4 of the Defamation Act requires, and it's what Data Protection Act, which is a privacy statute, a reasonable belief by the editor that it's in the public interest is what data protection requires. So there is some synergy between all of this.
You don't say it's a proportionality test.
I think if he should reasonably believe it's wholly disproportionate, then I think I accept there would be a problem. If he should, on a reasonable assessment, realise it's wholly disproportionate, then I think there would be a problem. My problem with the judges is not so much with the word proportionate, but the word necessary, which I hope is the word I've been stressing. And that, of course, has to be read with Roman 3 if one's dealing with the case of the public being misled. Lord, the injunction example is, with great respect, wholly unhelpful. The learned friend gets up and says with his great experience he would have got an injunction. I get up and say with my great experience he wouldn't have done. And it takes us absolutely no further. But can I just say this? It does raise some interesting questions about what facts would the claimant have disclosed to the court if this hypothetical injunction had been applied for. Would she have told the court that this letter was written with a view to public consumption if Mr. Markle leaked it? A point, incidentally, I have not referred to at all, but it's surely highly relevant to the 8-10 balance that there's a public-facing aspect to this document. Fully accept that it wasn't known to the newspaper at the time. The test is looked at in all the circumstances as they emerge before the trial. Would my learned friend have been saying to the judge, I should tell you that the letter does rather misrepresent the position in the run-up to the wedding. If he did, I think the judge's eyebrows would begin to rise about the public interest really in protecting this letter. is he telling the judge that the letter was deployed in the People? And incidentally, on notice, the newspaper did ask Kensington Palace before publication whether or not the claimant authorised the People article, and they got no response. And it's in the article. It's paragraph 16 of the first article. I'm not suggesting they said we're going to publish the letter, but they did ask Kensington Palace that question. So paragraph 16. But my Lord, my Lady, it really doesn't. The injunction, the hypothetical injunction applications are highly entertaining.
Sorry, Andrew, can you just give me the reference to the defence?
To the article.
The defence?
The article, I said.
It's not pleaded. It wasn't brought to our attention, was it? No, for all that it matters, this was not brought to the claimant's attention before publication.
It was raised in correspondence right at the beginning, I think before shillings were...
Well, we can't resolve that.
No.
Not pre-publication.
The Murray factors, I'm not going to spend any time on them, but they have rather shrunk into the background. Dealings with both the letter, we say, and certainly, and also the text of the letter are relevant. Now, what has happened was, the court will remember, the first Addleshaw letter was before the judge, saying there's relevant information to be given on 3 issues, and I'm not going to go back over this ground, but there it was. Now there's still another letter from Addleshaw letter saying the other 3 have got relevant evidence, but they have declined to produce it at this stage. Now, the interesting point is that the first Addleshaw letter, I think I pointed this out, includes that the palace staff can assist specifically about her intentions, I mean the claimant's intentions, in relation to the letter. It's in the 3rd bullet point. I think it's supplemental. It's supplemental bundle tab 12. And it appears that all of them can potentially give evidence. The first bullet point, as I pointed out at 129, we needn't worry about its copyright. Whether or not the claimant anticipated that the letter might come into the public domain, and whether or not the claimant, generally and in relation to the letter specifically, to the authors of Finding Freedom, that is not dealt with by Mr. Knopf. There must be more evidence to come on that issue. Now, it would be extremely odd if that evidence is in effect no evidence. You don't say I can help and then turn the lights off. There must be some material evidence yet to come from the palace staff in relation to this important issue. Can I just give the court the reference to the Kensington Palace refusing to comment on the sources of the People article? That's at 13.8.9 of the defence, at page 329. I'm grateful to my juniors. And Lord, this obviously is relevant to the easy air notion that further evidence may be available which might affect the result, particularly bearing in mind that the editor is entitled to have regard to other material disclosures. Lord, I know that Mr. Speck has a few enlightening words, no doubt. Thank you very much. Is there anything I can assist you on further?
No, thank you very much,
Thank
Mr.
you.
Caldecott.
My lords, my lady, they are very few, and I'm going to take it at quite a pace, if I may. The first point I just wanted to respond to was my old friend Mr. Mill was trying to suggest that the judge did address the weightiness of the right, and he gave you 3 references in the judgment, paragraph 139, 148, and then 155. 155 was the sentence that I'd already dealt with in the fair dealing part of the judgment, which is actually looking at proportion, and you have my submissions on that. The earlier 2 paragraphs are directed only to the question of whether or not the threshold is met such that copyright subsists. It is not addressing the question that I was addressing, which is the weight of any such copyright. That's point number 1. The second point is that my learned friend, when talking about Ashdown and my submissions distinguishing it, and in particular my submissions that Ashdown was a case where the only argument was about authenticity, went to our pleading at paragraph 1514 and showed my lords and my lady a paragraph referring to authenticity, and then proceeded to argue the case as if that was the entirety of what we rely upon. That's not so, and it's important that my lords and my lady know. You've been looking at a few of the paragraphs that I wanted to just show you a little bit earlier in my learned friend's submissions. In the amended defence, around about paragraph page 343. In fact, I'd also rely on paragraph 15.4 that my lady drew my learned friend's attention to, and 15.9 specifically there is the guts of the way in which my Lord Justice Bean identified the case, the loving letter and the olive branch depiction, 15.9. 15.13 is the allegation that the publication was in direct response to the People publication, and of course, perhaps most crucially, is that jumping over 1514, which my learned friend tried to portray as our only reliance, if you go to 1516, exactly what I was submitting to you is there. It's Thomas Markle's right to tell his version, including the contents of the letter. But that's obviously all in the context of those earlier paragraphs. So my learned friend's attempt to make it look as if our argument is just that run in Ashdown completely fails, and it's just not fair in my submission to pick out one paragraph that mentions an argument as to authenticity and to suggest that my argument is just no more than that. So that's the next point. The next point I've got on my list is the question of why have a trial? Well, all the submissions that my learned friend's been making on the weight of free speech, all the submissions that we have in the privacy side of the case, which clearly go to fairness, arguments about what might be possible to take as the structure point about taking more is actually less objectionable. There are many reasons why one would have to have a trial on copyright as well as the privacy. That's the third point. The fourth point, my learned friend suggests that when the issue is the tone and content of the letter. One can just describe it. It's pretty obvious in my submission that one cannot do that in any way that is convincing, particularly somebody in Mr. Markle's position who had been somewhat vilified in the press before, to just simply say, actually the letter that I got is not the loving letter that it's been depicted. It's important in my submission that he is able to say, look, this is the content of the letter, and that pretty much mirrors the thrust of the submission that my learned friend was making about how it's important on the free speech privacy balance too. In meeting that broader sting of the People magazine. The next point, very quickly, my learned friend mixed and matched. I wasn't quite sure what he was talking about in terms of whether he was addressing submissions to fair dealing or the balance with free speech at certain parts. He referred to the passage in Laddie at a part of his submissions where I think he was talking about the balance with free speech. That passage in Laddie is all to do with fair dealing. It's nothing to do with the free speech balance. Next point, he mentioned the handwriting article. The handwriting article he lumps together, or is happy to do so, and he's doing that because it is in fact one of 3 online versions published of substantially the same story. I'll give my lords and my lady the reference to Mr. Verity explaining that that is the modern practice of publishing online. You publish more than one at very close intervals in time. And just as an aside, that's exactly what you see with the People article. That's why that tab that my Lord the Master of Rolls says is so thick. What you've got there is the hard copy, and then you've got 3 versions online published about an hour apart. And you've seen the very last one focused all on the father. The middle one was focused on the same material but with lots of photographs, and then there was a shorter online one. But it's the modern practice, and in fact on the handwriting article, just 1 sentence was used for the handwriting analysis, and the rest of it is very similar to the other articles, covering the other stuff for the same purpose. The Article 10 rejection, my learned friend tried to say that the grounds for fair dealing and Article 10 in our pleading are substantially the same. I'd anticipated what he was going to say about the paragraphs relied upon as the underlying narrative, and that's why I said the underlying narrative paragraphs are either the same or very similar. But the actual grounds that are pleaded are materially different. The grounds, as you saw in the pleading, are different, and in particular, under the Article 10 balance, has a specific reference and reliance on Thomas Markle's free speech rights. And the very last submission that I needed to answer is the pro-sebum point. My learned friend suggested that my submission didn't help because I didn't get into overturning fairness by the submissions that I made. I was surprised at that because I'd already submitted quite separately to my lords and my lady as to how the conclusion on fairness couldn't possibly stand by, do you remember, attacking those 4 factors that my learned friend said were further factors on fairness, and the privacy conclusion was just 1 factor. I'd showed my lords and my lady why in fact 2 of those 4 factors were in fact privacy all over again, but in any event privacy is absolutely the central plank of the judge's conclusion on fairness. So if my learned friend persuades you on that, the fairness conclusion also must be arguable, and certainly the judge's conclusion cannot stand because that was basically the key part of his analysis. It's very quick.
Mendably quick.
Yes. I'm terribly. I told you I'd give you the reference for Verity 13. It's in the supplemental bundle, tab 6, page 58.
Thank you.
I've taken that at breakneck speed, but that's, I think, everything I needed to reply on, unless my lord or my lady have any questions.
No, thank you very much.
Well, I promised to remind you about the Times
Yes.
application.
So the Times made an application, and I've had an email which seems to indicate that part of it has been dealt with. Is there an outstanding part? Does anybody know? No? Well, they asked for Mr. Matheson's statement, I believe, and for the... Yes.
My lord, my name's Jess Glass. I'm
Please
the
take-
representative from the Press Association. I hope my colleagues from the Times won't mind me speaking on their behalf. My understanding is that we've had Mr. Matheson's statement, that there's the outstanding matter of the texts referred to in Mr. Knauff's statement. I believe I haven't seen the application, but I know that PA does support it from my colleagues who have seen it, just relating to the text, the schedule of the text.
The schedule of text.
Yes, or the text that referred to in Mr. Knauff's statement that have been referred to in open court.
Right. Have the parties any views on this?
We don't oppose the application for the text that Malone and Friend and myself were referring to. If that's the ones.
Yes, I believe so. The ones that have been partly referenced in Mr. Knauff's statement, but the full text in their context would be much appreciated.
Not opposed or answered.
Not
Text and the context. I'm not quite sure what you mean. You say the text and the context?
Yes, sorry, the schedule. I believe that there is a. I can pull up the part in Mr. Knauff's statement if required.
I think there's a schedule of texts that was appended to a pleading.
I think, my lord, the application is directed at the text that was supplied by Mr. Knauff. Is that right? After his witness statement.
Yes, Lord, it's texts and emails, I think, are next to Mr. Knauff's witness statement, is what I understood the application to be directed at. They came afterwards, so that's why they're not annexed.
They came in what sense? And where are they in my bundle?
They will be in the application bundle at tab 5.
I mean, were they referred to?
Some were. I referred to about 4 or 5 pages. I can probably...
Well, I'm looking at page 30.
Yes, I think I took the court to 31, 35, 37, 38 and 39.
Yes, you did.
Probably 40, 41 as well.
Yes, you did. Now,
And 43, I'm sorry, Lord, I'm interrupting. It's 43 to 46.
39, 41, 43,
And 47, I think.
44, 45. You referred to a lot of them.
I did.
I see. And there's no opposition.
The applications for complete copy of the text and email communications supplied by Mr. Knauff and submitted to the court.
My lord and lady, if it assists, I believe my colleagues are referring to the texts and emails referred to in part 14 of the Duchess's witness statement that we received yesterday. So it is the complete copy of the text and email communications.
Yes.
I wonder if I can.
Well, we haven't really been referred to the Duchess's witness statement at all.
No, it might help to cut through this. There's a slight possibility of confusion because the Duchess exhibits to her statement a fuller run of emails than Mr. Knauff provided. Not much fuller, but a bit fuller. So I suspect what the application really wants to get at is all the emails and all the texts. It doesn't matter whether it's in the form, perhaps, of those that are exhibited to the claimant statement or those that are supplied without an exhibit by Mr. Knauff. I suspect the parties between them can agree that. There's only one problem that Mrs. Phillips reminds me of, which is that the texts do include the full text of the letter, and not all of the letter was referred to by the judge in his judgment for good reasons.
Yeah, it should be redacted.
So it should be redacted.
So, yeah, you're happy with that, yeah. So, if the parties can sort it out, that's fine.
Yes.
If it seems to me certainly the letter should be redacted. If they can't sort it out by consent, then we'll deal with it in writing. It's not a rush, I don't think. As regards to the case, did you have something you wanted to say?
Yes, my lord, one very small point of correction.
Yes.
Paragraph 11 of the defence, page 319, admits in terms, and I quote, "It is admitted that the defendant did not contact the claimant before publication." I cannot assist, I don't have instructions on whether or not the defendant did contact Kensington Palace, when they contacted them, or whether that contact was even passed on to the claimant. But I base myself shortly and simply on paragraph 11.
Right, thank you very much.
I did give Your Lordship the reference to the defence where the contact is pleaded, which is 13.8.9,
Yes, you did.
page 329. Sorry, Lord, nothing worse than a fine.
No, I think we'll draw stumps, as we might say, now, and we will take time to consider our judgments in the usual way. We will hand our judgments down in due course in writing. When we do, you will please provide textual but not substantive corrections. The judgment will then be handed down remotely, and if you can't agree an order and costs and any consequential matters, we will deal with those in writing and not orally unless we otherwise direct. But may I thank counsel and solicitors for their helpful submissions, and obviously we will consider them with great care. Thank you.
So, Jen.